Hi, this is Stuart Talley. I'm here to do another update on the Pinnacle metal-on-metal hip trial that's currently ongoing in Dallas, Texas. Well, we have finally reached the end of the road. It's been about 10 weeks of testimony, more than 30 days of actual court time, and the parties today gave closing arguments to wrap up the case. Both the plaintiff and defendant gave closing arguments. And so now the jury actually has the case. And we'll see how long they deliberate and come up with a decision. The closing in this case was somewhat unique. The judge had very tight time constraints on the closing argument. Each side had an hour and 45 minutes to sort of tell their story after 10 weeks of trial. And so the arguments, the lawyers were really forced to be very specific and quick and succinct with their argument. The plaintiff's attorneys basically continued on a theme that they've had throughout the case, which is that DePuy really rushed this product to the market. That was one of their big themes. That the only reason they came out with a metal-on-metal hip was because they knew the competition might come out with something, and so that they wanted to beat them to the punch. There's actually a document that the plaintiffs point to repeatedly indicating that it was important that DePuy beat the competition to the punch with the metal-on-metal hip. So they put this on the market without adequate testing, without even knowing what metal ions could do to the tissue, and that was admitted at the trial. The second theme that they had and that they expanded upon was that this was an experiment gone bad. Again, DePuy didn't really know what the impact of metal ions would be on the tissue. They knew that there had been metal-on-metal hips in the past that had failed, but they released it anyway, and they released it, like I said, to beat the competition to the punch. The other thing that they talked about, another theme that was pushed pretty heavily by the plaintiffs in the case, was that DePuy knew there were problems with this hip. They knew it was causing problems in patients, specifically metallosis. It was causing tissue damage, but they did everything they could to hide that fact from the medical community. The plaintiff's attorney talked about the bogus studies that had been done. A study called the PIN study that there were lots of irregularities with, and it was a deceptive study. They talked about the advertising where DePuy told doctors that the hip was successful in 99.9% of the patients that received it. And I think the plaintiffs did a good job of showing that that wasn't true. They talked about the doctors who received millions of dollars in consulting agreements and royalty agreements. They were supposedly design surgeons, but it turned out that what these doctors were really receiving was money to prescribe the hip and use the hip. And they had agreements that required them to use the hip, and they got paid millions of dollars. Some of the surgeons actually made more than $40 million consulting for DePuy. All of that was pushed heavily by the plaintiffs. With respect to damages, there were 5 plaintiffs in this case. And what was interesting about the closing is the plaintiff's attorney didn't ask for a specific amount of money for any plaintiff. They left it up to the jury to decide how much each plaintiff should get. And the types of damages that plaintiffs can get in these cases are medical bills, future medical bills, but the real big number is something for pain and suffering. All of these plaintiffs had their lives substantially impacted as a result of these hips and the revision surgeries and the problems that they had with their hips. Many can't do the things they used to do. They can't enjoy life the way they used to. Some are in constant pain going forward for the rest of their life. The only sort of linchpin that the plaintiff's attorney gave to the jury was an argument that I think was very effective. What they argued was that when the jury goes back into the jury room, they need to figure out how long each one of these plaintiffs is expected to live for the rest of their life. And they have a chart that has that. And the argument was made that the jury should look at pain and suffering that people will have to experience on not just a yearly basis, but a daily basis. what is fair compensation to be in pain for a day? What's fair compensation to be in pain for an hour? And that was the argument that they gave. And the linchpin, or I think the thing that gave the jury some guidance, was an argument was made that the defendant's experts that DePuy brought in, many of them were paid $1,000 an hour to testify. And so what the plaintiff's attorney argued was that whatever you give the plaintiffs on a daily basis, it should be more than what one of their experts makes in an hour. And I think that was very effective. There was also an argument made that punitive damages should be awarded. Punitive damages are the amount that a jury can award against a corporate defendant to punish the defendant. And the idea behind punitive damages is that if you award an amount that's large enough, the company will stop engaging in the conduct in the future. Punitive damages are only available if you can show that the company committed fraud, or knowingly or acted knowing they were going to hurt people, or with a reckless disregard for the safety of people. With respect to Johnson & Johnson and DePuy, what the plaintiff's attorney explained was that the company is worth $69 billion. And that is an enormous number that's very difficult for people to wrap their head around. So the argument was made, and the jury was told to consider what would happen if you were dealing with somebody that had $69,000, and you were trying to punish that person who had $69,000. If you awarded $100 in punitives against that person, that really wouldn't be much of a punishment, even $200. And when you convert that into Johnson & Johnson's realm and their $69 billion, that comes out to $200 million. $200 million would be to Johnson & Johnson what $200 would be to somebody who had $69,000 in their pocket. That's all that was said. And I think the idea behind that argument and that line of discussion was that there's an effort to get the jury to see that something in the $100 million range is not sufficient to punish this company. It's got to be something in the $1 billion range. Whether the jury will award punitive damages, we'll see. I think a strong case was made for it. On the defense side, the defense got to make a closing argument as well. And their argument was that DePuy is really a good company, that they have invented medical devices that have helped many people over the years, and that the plaintiffs went through 90 million pages of documents, and yeah, they found some bad emails, some things that they didn't like or that looked bad, but you got to look at it in the overall context of this company. There was an argument that it's a good company that helps people, and they were trying to help people with this metal-on-metal hip. The real focus, though, of the defense argument in this case is what we call causation. So the real question is, even if you assume this hip is defective and is shedding metal particles, is that why each of these plaintiffs needed a revision surgery? Is that why they had problems? And so for each of the plaintiffs, they went through the reasons why they think that the person's problems with their hip were not related to metal particles. So for one of the plaintiffs, they said that the hip was not stable. It was loose. And that is why there was metal wear debris. That's the only plaintiff that they admit that metal wear debris had anything to do with their problems. But because the hip was unstable, it's not their fault. That's the surgeon's fault. The second plaintiff, they said, had sarcoidosis, which is this inflammatory disease. And that's why they were having problems with their hip. The third plaintiff, they said, had a hypersensitivity reaction to metal particles. In essence, they argued the person's allergic to metal, and that's why they had the problems. There's lots of issues with that, but that's their argument. The other two people, they indicated probably didn't even need revision surgery. That any kind of problems that they had had no relation at all to metal particles, and that their surgeons did a revision surgery that never had to be performed. After the defendant gave their closing statement, the plaintiffs had a chance to come back and do a rebuttal closing. On rebuttal, I think the argument was very effectively made that the experts hired by DePuy were what the plaintiff's attorney called jukebox witnesses. These are witnesses where you put the money in and they play what you want to hear. Because what is important in this case is that all of the treating surgeons, all of the surgeons that actually treated these patients did the revision surgeries, the ones who actually went in there and saw what was going on in the hips. All of them said that the person was having a reaction to metal wear debris and that they needed the revision surgery because of problems with the hip. There was also a discussion of what the defect is. During the defendant's closing argument, they argued that the hip was not defective, that there was no showing that the hip was defective in any way. And that was fairly easily dispensed with by the plaintiff's attorney, who explained that the problem with this hip is that it's a metal on metal hip. You should never have a situation where you have two pieces of metal rubbing against each other inside the human body, which would seem to be common sense. The evidence that this product is defective is that they don't sell it anymore. Nobody uses it. The FDA has specifically said that these products cannot be sold unless you do clinical trials on the product before it's released, meaning you have to test it in people and see what happens. So at the end of the day, I think the plaintiffs came out with a very good argument on closing. I think the documents in the case are very bad for DePuy. I think the amount of money that was paid to the experts and to the consultants that they hired were enormous amounts of money that I think are really going to have an impact on this jury. But you never know what's going to happen when you're talking about a jury and you talk about a trial. Anything's possible. So we are waiting for a jury verdict. We'll see what happens, and when a verdict comes in, we'll obviously provide another update.